late, I had a fellow judge down in Tennessee who has considerable influence on me. The Honorable Jimmy White called, and we had two judges on there to do something. Can't ever tell when some of our brethren go across the line, we need to call him. I guess we have some case right now with interpreters. We need to take those up first, you think?
Okay.
Javier Dominguez, is that correct? Is that the only case y'all have today? Only interpret. Do you have another one? Well, now you would know.
That's the only one on my list.
Okay. Okay, will you interpreters raise your right hand? You solemnly swear or affirm that you are authorized in the Commonwealth of Kentucky to give services as far as interpretation. Both of you do that, and you will honestly do that. Thank you. Lower your hands. Commonwealth of Kentucky versus Javier Dominguez, is that correct? 25 CR 0029. Mr. Dominguez, were you born in 1995?
Señor Domínguez, ¿nació usted en 1995?
9 de diciembre.
You need to.
December 9th.
December 9th. He needs to speak up, so tell him it's a voice activated mic.
Hablar en voz alta para que el micrófono se active y podamos oírlo.
Excuse me. Do you have a social security number?
¿Tiene número de seguro social?
No.
Okay,
No.
we're here for a pretrial conference.
Estamos aquí para una
What does the Commonwealth have to say?
Felony plea.
Okay. A motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
¿Desea declararse culpable el día de hoy? ¿Es correcto?
Sí, por supuesto.
Are you
Yes.
currently under the influence of drugs or alcohol?
¿Está bajo los efectos de alcohol o drogas?
No, ninguno.
No.
Is this plea freely and voluntarily given?
¿Se va a declarar culpable y libre y voluntariamente?
Perfecto.
Are you the same person we just identified in 25 CR 0029?
Está acusado en el caso 25 CR 29.
Sí.
Is your judgment impaired today in any way?
¿Su capacidad para decidir está afectada de alguna manera el día de hoy?
No, ninguno.
No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Y está conforme con el asesoramiento de su abogada.
Sí.
Yes.
Okay. Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your case?
¿Y está completamente informado de su caso?
Sí, claro.
Yeah.
Yes.
You understand that you do not have to enter a guilty plea today.
¿Va a declararse culpable el día de hoy?
You have certain rights under the Kentucky and United States Constitution.
La Constitución de Kentucky y de los Estados Unidos.
Before I can accept a plea, I need to know that you understand those rights.
Ya, necesito saber que usted entiende esos derechos.
I'm going to go down through the rights and at the end, I'm going to ask you if you understand.
Le voy a preguntar si usted comprende.
If at any time you need a moment to step away from the podium and consult with your attorney and interpreter, you just ask for that opportunity. Okay, you have right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury.
A un juicio por jurado sin demora.
The right to be represented by counsel at your trial.
por abogado en el juicio.
You have a right to confront and cross-examine all witnesses called to testify against you.
Digo que vengan a declarar en contra de usted.
The right to produce evidence.
Derecho a presentar pruebas,
The right to call witnesses in your favor.
a testigos en su defensa.
The right to appeal this matter to higher court if you lose.
Este caso ante un tribunal superior si usted pierde.
And the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges.
Que usted es culpable más allá de una duda razonable.
You understand by entering a guilty plea today, you give up those rights.
Declararse culpable, usted renuncia a todos estos derechos.
You understand that?
¿Entiende eso?
Sí,
Now, I
Yes.
may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law.
La fiscalía, pero también podría imponer una pena más alta que de la recomendación.
Prior to accepting the recommendation, I will order a pre-sentence investigation report to be done by probation and parole.
Una investigación precondenatoria que realizará la Oficina de Libertad Condicional.
In the event that I do not accept the Commonwealth's recommendation
La recomendación de la fiscalía
and decide to impose a harsher sentence,
para imponer una pena más alta,
you have a right to withdraw your plea and go to trial.
a retirar su declaración de culpabilidad e ir a juicio.
So I cannot give you more than you've agreed to
No le puedo dar más de lo que usted ha acordado,
unless you agree to that change.
a menos que usted esté de acuerdo con el cambio.
Who's doing the Commonwealth's recommendation? Ms. Gordon Anderson, will y'all move to the left just a little bit so she can get behind the microphone? Okay, now listen very carefully here.
Upon a plea of guilty to burglary second degree,
De entrada ilícita con fines ilegales en segundo grado,
the defendant shall receive a sentence of 5 years to serve.
el acusado recibiría una pena de 5 años antes de juicio.
The defendant shall receive credit for time served.
También el acusado recibiría crédito por el tiempo que ya estuvo en la cárcel.
The Commonwealth opposes probation and shock probation.
Y la fiscalía se opone a la libertad condicional aprobatoria y a la probatoria libertad condicional por choque.
Okay, you move back over here.
Regresemos aquí.
Is that your understanding of the Commonwealth's recommendation?
¿Es esa la recomendación que usted había entendido que iba a hacer la fiscalía?
sí, sí.
Are you pleading guilty because you did commit the acts charged in the indictment?
Porque usted cometió los cargos de los que fue acusado formalmente.
Ah, perfectamente. Acepto todo porque
Yes, I accept everything.
Okay. Now, knowing your constitutional rights, as I explained it to you,
Los derechos constitucionales que le expliqué
is it still your desire to
es su deseo
continue with your plea and allow the court to fix your punishment?
continuar adelante con la declaración de culpabilidad y que el juez le imponga la pena.
Do you understand that after entering a plea of guilty, any future convictions of felony can be enhanced as far as the penalty?
Si cometiera más delitos graves, las penas podrían ser cada vez más altas. Yes.
Now, I accept the agreement. I will order a pre-sentence investigation report.
Que se realice
You will be sentenced on September 16th.
y la fecha para la imposición de la pena o sentencia será el 16 de septiembre.
Okay, the probation and parole
La
individuals will meet with you and they will have an interpreter on the phone to take the information. That's how y'all do it now, isn't that right? Okay. And that information will be used to determine how I handle your sentencing.
para determinar cómo se impondrá su pena, su sentencia.
Is that your signature on the document?
¿Es la firma de usted la que está en el documento?
I've already asked you that once. So.
sí.
Yes.
Okay, well, thank you very much. And
Bien.
the probation pro will be to see you in the next few days. Thank you. Now, Madam Clerk, or is there any other need for an interpreter today or anything? Okay, the interpreters may be excused. Thank you for your help here today. Have a safe trip home. Stephen Brown.
Have to look in.
Y'all need a second or two more with him before you leave, since you got an interpreter now.
No, no, we're just letting him know.
Okay, that's good. Well, then move it over that way then, okay? Are you Stephen Brown?
Yes.
Good morning. This is 23 CR 0063, 24 CR 005, 25 CR 001. You're here on 2 probation revocations and a pretrial conference. Is your year of birth 1980? Last 4 digits, social security number 0396.
Yes.
What does the Commonwealth have to say about Mr. Brown's case?
I believe Mr. Davis and I conferred about this morning. We thought this was going to be on the docket in October, I believe. And so we had.
I think my calendar says September.
September, I'm sorry.
But yeah, we agreed to give my investigator a little time to look at
So
it.
I would ask it be set for September 5th for negotiation and September the 18th for pretrial. And if it's not resolved, then I'll ask for a
September
trial.
16th,
Yes, sir.
isn't it? September 16th.
It's 18th, I believe, Your
No,
Honor.
16th. It's been moved.
On
Yeah.
on a Tuesday?
Yes.
16th.
Oh,
not
well,
marked
that
out.
may present a problem for me.
Okay, well, you can get back with Mr. Stockton. You can still go on the negotiation day. And-
Okay.
And if you want your client present on the negotiation day, you'll need to submit a transport order, okay?
Yes, sir. Well, can we just set that for the October date? I already have, I'm supposed to be in other counties on the 16th.
If that's okay with your client, it's okay with me.
That's
Okay,
fine, please.
it'll be fine. Okay, we'll do it for October the 16th.
Thank you, Your Honor.
Okay, and you still want him there on negotiation day on the 5th or?
Yes.
Please.
That way it gives
And
you some
yes,
intervening
sir.
time. Okay,
Yes, sir.
thank you very
Thank
much.
you, Your Honor.
Have a safe trip.
Well,
Okay, what else do you have?
Your Honor, I have Chris DeWeese.
He's out, is he out of custody?
He is,
I'll
sir.
let you go ahead and do that so you get on the road.
My apologies. Thank
No
you, Your
problem.
Honor.
Commonwealth versus. I don't see him on here.
Chris
Yeah,
DeWeese.
Christopher DeWeese. Yeah, Commonwealth, are you Christopher DeWeese?
Yes.
Were you born in 1969? Last 4 digits, social security number 4272.
Yes, sir.
This is 25 CR 0028 for a pretrial conference. What does the Commonwealth have to say?
And Your Honor, I would just, if I may, I believe we're waiting test results. There's no test results in the file. If we could set this for the October date as well, I think
That'd be fine.
What's the negotiation date in October?
Be October the 3rd.
October the 3rd for negotiation and October 16th, the next court date. Both of those are conditions of your bond, sir, okay?
Yes, sir. Thank you, Your Honor. May I be
No problem.
excused, sir?
Absolutely.
Thank you, Your Honor.
Okay, Claude Kevin. Claude Kevin. Are you Claude Kevin?
Yes, sir.
Good morning.
Good morning.
Were you born in 1998?
Yes, sir.
Last 4 digits, social security number 0475.
Yes, sir.
We're here on 24 CR 0082, a motion for shock probation. You want to present?
Yes, Your Honor. So we had filed a motion for shock probation for Mr. Cavan. However, I've spoken with Mr. Stockton, and I think we have agreed to pass this until next month. That way that I could potentially line up a treatment program for Mr.
Yeah,
Cavan.
if he was revoked because he wouldn't quit driving. If she can line up a treatment program where he's not required to drive anywhere, I might be agreeable to shock.
Okay, well, I won't rule on it today, then I'll leave it open. I'll take it under advisement. And we'll be back here on September the 16th.
Thank you.
Yes, Your Honor. Thank
Okay,
you.
no problem, yeah. Derek Graves,
I need that side.
Commonwealth versus Derek Graves, 18 CR 0016. Are you Derek Graves?
Yes.
Good morning.
Good morning.
Were you born in 1994?
Yes.
Last 4 digits, social security number 1206.
Yes, sir.
Okay, we're here on a motion for shock probation. What do you have?
Yes, Your Honor. Mr. Graves, I believe, has been in custody since roughly April of this year. Mr. Graves is asking for the court to consider granting him shock probation
What
at
was
this
the underlying
time.
charge?
Your Honor, I believe that his,
What quantity was involved?
It was less than 2 grams, I believe. I can tell according to the minute.
And Your Honor, Mr. Graves is interested in participating in an IOP program if he is released.
The problem we've got with this case, Your Honor, is Mr. Graves, this is the 18 case. We've had 4 motions to revoke filed. The court has given him so much alternative sentence and he's already got 2 years and 10 months, 10 days in credit because he's been in jail so much.
When's he for parole board?
But he won't meet the parole board May of 26, so I guess he just got blocked. The reason he filed this motion.
That is correct, Your Honor.
But we just don't know whether he's going to comply with probation based on his past record.
It's kind of, you think that's the reason they flopped him because it's non-compliance down through the years? I mean, it's unusual.
It is unusual. I would have thought with as much time as he had in there with a parole now. But they didn't. And well, I'm just afraid we'll be right back where we started. We'll probate him out. It'll be the 5th motion.
Well, here's the thing, if you can present the Commonwealth for some compelling reason that we ought to put his conduct in the past, like an employment record or something like that, or something he has, or some belief, he's not eligible for drug court, right? Is he eligible for drug court? No, he's not eligible for drug court again. Okay, well, I'll take it under advisement. I'll give you an opportunity to convince the Commonwealth to go along with it.
Yes, Your Honor.
Thank you.
Thank you.
Yeah. Brian Hunter. Brian Hunter. Commonwealth versus Brian Hunter, 24CR004. Are you Brian Hunter? Good morning. Were you born in 1992?
Yes, sir.
Last 4 digits, social security number 3209.
Yes, sir.
We're here for pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, that Mr. Hunter has a 3-year sentence on possession. He was in drug court. And I counted up, he had about 8 positives for meth. I believe he went to rehab and then had another positive.
Stipulate.
We are stipulating, Your Honor.
I'll let you be heard on.
Your Honor, he is wishing to go ahead and be revoked on the pretrial diversion, and then we would approach the court at final sentencing.
Okay, I'll revoke pretrial diversion, order pre-sentence investigation report to be done by probation parole and have sentencing on September the 16th, okay?
Thank you.
Thank you very much. Ethan Lynn. Ethan Lynn. Commonwealth versus Ethan Lynn. Are you Ethan Lynn? Good morning. You're here on 25CR0026. Were you born in 1990?
Yes.
Last 4 digits, social security number 8958.
Yes.
We're here on a pretrial conference.
If I may approach with the plea agreement.
Well, no, I'll let you hold it
But we have a
there.
plea agreement. How
Okay.
about that?
Is it a felony plea?
Yes, Your Honor.
A motion has been made, sir, that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in this indictment?
Yes.
Is your judgment impaired in any way?
No.
Have you discussed these charges with your attorney and are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about the case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to go over those rights. If anytime you have any question, step away from the podium and ask your attorney, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, your right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you, your right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. Understand that by entering a guilty plea today, you waive and give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will await a pre-sentence investigation report to be done by probation and parole. In the event I do not accept the recommendation after having reviewed that report and decide to impose a harsher sentence on you, you'll have the right to withdraw your plea and go to trial. You understand that?
Yes.
Move to the left, please. Y'all move to the left. Ms. Gordon Anderson, what is the Commonwealth's offer?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, third or greater offense, the defendant shall receive a sentence of 1 year to serve. The Commonwealth will impose probation. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agreed to, sir?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment as amended,
Yes.
doing this of your own free will?
Yes.
Knowing your constitutional rights, I've previously explained to you, is it still your desire to proceed with your plea and allow the court to fix your punishment with an arrangement of the law? You understand that by entering this plea, any future convictions would have an enhanced penalty under persistent felony offender law. You understand that? Is that your signature on the document there?
Yes.
I'll accept the plea agreement, order pre-sentence investigation report done on and then you return on September the 16th for sentence. Okay?
Okay.
Okay, thank you very much. And we'll talk about court costs and things then.
Is that a Tuesday, Judge?
It is on a Tuesday.
Okay, just making sure. Judge, I also had Jesus Padilla. It's my understanding that they didn't receive the transport order in time to transport him. I've called the facility. And so he's not gonna be transported. So I guess we'll need,
Where was Jesus?
he's at Green River Correctional Complex, Judge.
What was the motion for that?
He was going to be entering a felony plea today. We
Yeah.
agreed.
He's agreed to the Commonwealth's offer. We were gonna do the plea.
What facility is he in?
Green River Correctional Complex.
Has he seen the?
He has not, Judge.
Okay.
They sent me the
We could
paper.
probably get him we could get him on Zoom, but you wouldn't be comfortable with that since he hadn't seen it.
Yeah, and he hasn't seen the plea form, Judge, and like I said,
Okay,
where
no
he's a
problem.
state
Well, let's
inmate.
just set him, like you say, he is a state inmate. Let's set him for September the 16th.
Okay, and I'll submit another transport order today so that they can't say they didn't get enough. Yeah, so they can't say they didn't get enough warning.
Okay,
Thank
thank you
you,
very
Judge.
much, yes. Callie Strong. Commonwealth versus Callie Strong, 22 CR 0061 for sentencing. Are you Callie Strong? Good morning. Were you born in 1969?
Yes.
Last four digits, social security number 7609. You're here for sentencing in 22 CR 0061. Have you had an opportunity to look at the pre-sentence investigation report done on probation and parole?
Yes.
Is it substantially correct?
Yeah.
Yeah. You were pretrial diverted for 5 years. Your pretrial diversion was voided on July 17th, excuse me, on possession of controlled substance, first degree methamphetamine. So I will impose,
Your Honor, we're hoping to make a motion for probation at
oh,
this.
go ahead then.
Yes, Your Honor. Mr. Strong's pretrial diversion was set aside due to a drug court termination. It was alleged that he had absconded from drug court. Mr. Strong had been suffering from some severe transportation issues at the time, though it is my understanding he had turned himself in on the warrant for this case and that he was clean at the time that he did so. We are asking for him to be given the opportunity to complete probation for this case rather than to serve the sentence that is imposed.
How's it come on, say?
I agree with Ms. Hill that he did turn himself in to Mr. Richardson when he found out about the warrant. He was clean. So if the
Yeah.
court wants to do that, or we'll either look at probation or shock probation.
I think we need to look at shock probation. I have to take seriously the drug court situation, you know, with everybody else there. It does seem like the violations were pretty tough. So when it comes, you know, wait till a little while longer than the minimum shock probation. I'm sure the Commonwealth will look at that. Are you disabled or is this a temporary thing you got here?
Oh, I'm disabled, Your Honor.
Pardon?
I'm disabled.
Okay. Well, you know, so I usually tell people to take a look at employment situation. You know, and that's not situation here now. So you'll come back, not more than 30, but not less. Is that right?
Yes, Your Honor.
More than 60, is it more than 60? Not less than 60.
Not less than,
Okay. Well, as soon as you're eligible, she'll find a motion, get you on the docket. Thank you. Damon Tackett. Are you Damian Tackett?
Yes, sir.
Good morning. We're here on 25 CR 0019 for sentencing. Were you born in 1984?
Yes, sir.
Last four digits of social security number 4520.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Is there any reason, Counselor, why this gentleman should not be sentenced today? Upon a plea of guilty to criminal mischief, he shall receive 5 years probated, 5 years supervised, but the defendant shall pay restitution of $1,592, a rate of $100 plus per month, plus 5% clerk's fee. First payment being due 30 days after his release from incarceration. And what's the court cost on this?
270.
Okay, I'll let you pay an additional $30 a month on that. So your total payment will be $100 to restitution, $30 toward court costs. So it ought to be something that's manageable. Do you have a job?
Be honest with you, I've
But
been
it's good to be
incarcerated.
honest with me. It's always preferred.
Be honest with you, I'm not for sure because I've been incarcerated so long, so they may have held my job and they may not.
Where did you work previously?
McDonald's, $14 an hour.
Yeah. Well, there are people, how's that there, this
But
McDonald's here?
I'll get a job.
Yeah,
That's the
yeah,
thing.
you can get a job.
Right, right.
If you're willing to work, it's always a good indication to me if somebody's out there trying to work,
Yes.
okay? Okay, take it easily.
Please be released.
Dakota Williams,
Please be released.
are you Dakota Williams? You are. Okay, good morning, Dakota. You're here on 22 CR 0018 and 22 CR 0019 and 22 CR 0021. Were you born in 2003?
Sir.
Okay, and the last four digits, social security number 4744. We're here on
741.
4741. Okay, that's a misprint. I had it corrected. You're here on shock probation on those three charges. Tell me what the story is on Mr. Williams.
So, Your Honor, we had a revocation proceeding last month on this where I believe Mr. Collins testified that Mr. Williams had picked up a couple of new charges. I believe the court stated at that time that there wasn't enough information to revoke. And so you wanted to wait and see whether or not he was indicted by this month. He has not yet been indicted to my knowledge.
Here,
Yes.
So
I would say if he's indicted, I would ask for a negotiation day, another motion dates, if he's not indicted, you let me go. But I think based on the case we've got, I think it'll be.
okay, well, so what they're saying, Mr. Williams, is that if you do get indicted today, they're gonna roll all these things in together instead of negotiation day, so you can try to take care of them all at once. And that will be on September the 5th. And so the next court day, it comes earlier a little bit next month, I guess. The negotiation day will be on September the 16th on a Tuesday. Okay,
He is indicted, we'll first Ms. Hill the discovery on the new case
okay.
before the bill, so she can.
That way they won't have to wait to arraign you, you lose another month, okay?
Yeah.
Okay, thank
We
you.
do that, Jim.
Y'all have anybody else? Okay, well, thank you. Kelly Bratcher. Commonwealth versus Kelly Bratcher, 21 CR 00102. Are you Kelly Bratcher? Good morning. Were you born in 1981?
Yes,
Last four digits, social security 9331.
yes, sir.
You're represented by Mr. Bell. What does the Commonwealth have to say about this?
Can we have one more negotiation? Mr. Bell and I have discussed this. There's an issue we need to resolve.
Mr. Bell. Yes, sir.
He's always causing problems.
Yeah, I don't know. If you don't watch it, Mr. Bell will get you out of this. You gotta
I'm
you gotta watch him. Yeah, okay. Let's set a pretrial, let's say a negotiation day for September 5th. And the next, is September 16th. Okay, what are the charges here?
It's a possession case, but there's some other issues, so.
Okay. All right, I got you.
Thank you, Judge.
Okay, thank you. Yeah,
On Damien Taggart that you sentenced, I believe he's to be released. I needed to know about probation and parole when released.
yeah, you need,
Yeah, he indicated he lives in Tennessee. So probably Monday in Glasgow would be great because it's a.
okay, well, why don't we tell him that you'll be over there on Monday to see him, he won't get released to then. They started back with him yet? Okay, why don't you go back and explain it to him, that way he won't have to worry about that over there. Ashley Compton,
The next one's like Cummins, the Rocky Dog.
okay. Courtney Cummins. Commonwealth versus Courtney Cummins, 25 CR 0035.
Skip time.
Are you Courtney Cummins?
I am.
You're here for the purpose of arraignment and to enter a plea. What, your year of birth is 1988,
81.
81, okay. And what's the last four digits of your social security number?
9906.
Okay, you have the information indictment here. You have, or the information, rather, it's not an indictment. By information, you have been charged with possession of a controlled substance, first degree, first offense, methamphetamine against the peace and dignity. You acknowledge the identity of your client, receive the information, waive formal reading.
I do, Your Honor.
And are ready to enter a plea.
Yes, Your Honor.
I understand. Is this a pretrial diversion or a felony plea? Pretrial diversion, okay. A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CR 0035?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed the charges with your attorney?
Yes.
Are you satisfied with the advice of your attorney?
Yes.
Have you viewed the evidence the Commonwealth has against you?
Yes.
Believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand that by entering a guilty plea today, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial.
I understand.
Okay, now I have certain qualifying questions that I have to ask you. Have you previously been diverted in the last 5 years? Have you felonies in the last 10 years?
No.
Are you presently on probation or pretrial diversion?
No.
Do you understand that if you complete successfully the diversion program, the charges will be dismissed pretrial diversion? You can have your record expunged.
I understand.
And you understand that if you do not fully complete the program, you brought back and forth before the court, and I decide that you violated the pretrial diversion, I will schedule a sentencing for you.
I understand.
You be a convicted felon that can be used against you in the future. You understand that?
I do.
Y'all step to the left, please. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 4 years, supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes.
Are you entering guilty plea because you did commit the acts charged in the indictment as amended? Are you pleading guilty because you did commit the acts charged in the information as amended?
Yes,
Okay. You do so of your own free will.
yes,
Knowing your constitutional rights to explain to us, it's still your desire to give up those rights, enter a plea of guilty to charges and allow the court to fix your punishment within the range permitted by law.
yes,
Is that your signature?
yes.
Okay. Show the signature. You have the original there, Mr.
I've
Carter?
got the copies, Judge, the original, I think or maybe these are
Well, we don't want you to leave with them.
I think the original's been submitted, but I have copies.
You have the originals? We do not have the originals.
I think we do.
We wouldn't have the originals.
No.
Well, I'll accept the agreement, signed and delivered.
Actually, I have it right here. It's under my copies. I
Yeah.
apologize, yeah. So,
We'll make sure we get it. It does us more good than it will you. From this point forward, I'll accept the agreement. What are the court costs involved in this? Do what? $165? You need some time to pay that?
No, I can have.
Okay, we'll pay it today, and then you'll need to meet with probation and pro for a short interview, okay?
Thank you.
Okay, thank you.
thank you, Your Honor.
Yeah. Ashley Compton, are you back in the courtroom now?
I don't have an order granting pre-trial diversion.
We need to submit an order, somebody needs to submit us an order granting pretrial diversion.
Have the information in the two motions. The place, yeah, I don't have to play either.
Once y'all take Mr. Carter's file and I'll go through it real carefully.
Yeah, shoot what you want.
Yeah.
Do you have to pay?
Are you Ashley Compton? This is 25 CR 0037. You having a lawyer? Did you represent her in district court? Okay, I'll continue that. Ms. Compton, you're here on 25 CR 0037 for arraignment. Were you born in 1984?
Yes, sir.
Last four digits, social security number 3573.
Yes, sir.
The grand jury of Monroe County has returned an indictment charging you with public intoxication and possession of a controlled substance of first degree methamphetamine. Counselor, you acknowledge the identity of your client, receive an indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, we'll set a negotiation day on September the 5th. And thank you. And the next court date's on September 16th. And both of them are conditions of your bond, young lady. You hear me?
Yes, sir.
Okay. I'm signing a reciprocal discovery order. Requires the Commonwealth to provide information. You help you prepare for your defense.
Thank you, Your Honor.
Thank you. Kevin Page. Kevin Page. Commonwealth versus Kevin Page, 25 CR 0024. Are you Kevin Page? You born in 1971? Last four digits, social security number 6580. You're represented by counsel here. We're at a pretrial conference. What do you have?
Yes, Your Honor, this is Mr. Kevin Parent's case, another attorney from my office. I believe there was an agreement to pass this until next month.
Yeah, Mr. Lynn's entered a plea now, so we'll give him one more negotiation, one more pretrial.
Okay, the next negotiation day is September the 5th, and the next court day is September 16th, and we'll have a decision then on whether there's a plea or we'll set you a speedy trial date, okay?
Thank you, Your Honor.
Yeah. Jackie Poland. Hello. Commonwealth versus Jackie Poland, 25 CR 0036. Are you Jackie Poland? Good morning. Were you born in 1986?
Was.
Last four digits, social security number 6842.
Yes, sir.
This is a rocket docket case. Is that
Yes, Your Honor.
correct? Will you provide me with the information?
Got it, Your Honor. It's not in the file.
I got it here. Counselor, you acknowledge the identity of your client and receipt of the information. Mr. Bailiff,
I am, Your Honor.
you waive formal reading and are ready to enter a plea. Is that correct?
Yes, sir.
It's a felony plea or a pretrial diversion.
It's a felony plea.
Okay. Okay, a motion's been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0036?
Sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
sir.
Is your judgment impaired today in any way?
No, sir.
Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you fully understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. And the right to require the Commonwealth to prove on a reasonable doubt that you're guilty charged against you. Understand that by entering this guilty plea today, you give up those rights. You understand that?
Sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. Prior to accepting the recommendation, I will have a pre-sentence investigation report done by probation and parole. In the event after reviewing that, I don't accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of agreement and proceed to trial. Maybe y'all step to the left here. What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2 years, probated for 4 years, supervised. The defendant shall enter and complete the Monroe specialty program. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to? Are you pleading guilty because you did commit the acts charged in the information?
Yes, sir.
You do so of your own free will,
Yes, sir.
knowing your constitutional rights to explain to us to your desire to proceed with your plea and allow the court to fix your punishment in the range permitted by law. Is that correct?
Yes, sir.
You understand that after entering this guilty plea, any future convictions of felonies could be enhanced as far as the range of penalties. You understand that?
Yes, sir.
Is that your signature on the document?
Yes, sir.
I'll accept the agreement order, pre-sentence investigation report sentencing shall take place on the 16th of September, which is a Tuesday. This was a recommended probated sentence.
Yes, with Monroe Specialty Court.
Okay, with the specialty court. I'll go ahead and allow him to remain free on his same bond, but he needs to meet with the specialty court people. Have we done a referral on it yet?
There's an order.
Or referring, so you'll need to meet with them. And it'll be next month before you can be voted in anyway. They won't meet again until next month. So work carefully with them and diligently modify your activities so you won't fall out before you get going on that,
Yes, sir.
okay?
Yes, sir.
Probation, when can he meet with probation and parole?
We'll meet with you today.
Okay, they'll meet with you today to get the information. Okay, thank you very much.
And Judge, that's all I have.
Have a safe trip. Danny Sheffield.
All right, I'll see you around.
Danny Sheffield. Commonwealth versus Danny Sheffield, 25 CR 0030. Are you Danny Sheffield? You born in 1961? Last 4 digits, social security number 8702.
Yes.
Okay, you have it on a pretrial conference. What does the Commonwealth have to say?
My understanding is Mr. Bell either had a motion to file or was going to file something for next month.
I was hoping to, Judge.
What kind of motion you got?
It's a search and seizure issue. There was the only.
Constitutional things. You're constantly trying to invoke the Constitution.
Sometimes, Judge, it's all you got.
I was, the former Commonwealth attorney years ago, Paul Carter, when I was practicing, he said, Why don't you ever quote any Monroe County law? Said you're always bringing this Supreme Court stuff up here. Are you gonna file it pretty soon? It is a warrantless search, or what have we got going on?
No, they had a search warrant judge and an affidavit, but it only listed like the home and I believe the vehicles. There was an outbuilding that was searched in addition,
Obviously outside the curtilage, right?
in my opinion,
Yeah,
Judge.
sure.
And I mean, that's the whole issue. I've spoken to both Mr. Stockton and Miss Anderson about the issue.
I'm sure they were very receptive to your arguments.
Well, they didn't throw in the towel, that's for sure.
Okay, on we have a negotiation day for you on September the 5th,
Yes, sir.
just in case, and you have your motions filed. And if in your investigation you have second thoughts, you can appear to negotiate. And if you're going to proceed with your motion, you can even negotiate and say what you would do if, and that'll pick a month up for him that way, okay?
Yes, sir.
So
Judge.
have him back here on September the 16th and negotiation on the 5th.
Yes, sir, Judge. Thank you.
Okay, we're on for Bell County forestry camp. Are y'all on there yet? Bell County, yeah, I see on there. We're just a few minutes early, but Bell County forestry camp, would you come on? Turn your camera on. Okay. Okay, are you William Miller?
Yes, I am.
Good morning.
Good morning.
Thank you so much. We're on 25 CR 0025 for pretrial conference. Mr. Miller, were you born in 1980?
Yes, I was.
Last four digits, social security number 2359.
Yes.
Okay, we're here for pretrial conference. What's the Commonwealth? Your attorney's present here today. Would you identify yourself, sir?
Yes, sir. Kevin Perrin with DPA, PARENT.
Okay, what does the Commonwealth have to say?
Well, my notes indicate I wasn't here at the last negotiation, but evidently Mr. Miller was not transported here to negotiation. So.
Okay, well, let's set him a new negotiation date and make sure that you prepare a transportation order.
Your Honor, I did. I got that submitted on the Monday. And then I contacted Bell Forestry.
You need to speak up so he can use it.
Yes, sir. I did submit a transport order and you were able to sign it. I don't believe DOC ended up transporting him. I did call Bell Forestry that Friday 3 different times, talking to 3 different people.
When did you submit it to them?
I submitted it on Monday, I believe.
Okay, well, it might be a little short notice for them. I don't know. When do we hear anything
We
from them?
request them on by Tuesday for a Friday negotiation.
He had just gotten moved to Bell County, so I was
Okay,
able.
well, let's do another order here and have him give benefit of the doubt, have him here on 9 a.m. on September 5th, and the next court date
Yes, sir.
is on September 16th. What is Mr. Miller charged with?
He started with possession. We were having a discussion over here. I think Monroe County would be responsible for transporting on a D felony rather than the forestry camp. If it's a C or above, they would.
What's he doing at the forestry camp?
Your Honor, he got revoked. So he's serving
Stayed
for
in
5
there.
years.
State inmate?
So you might want to check on that and see who's responsible
Well,
for doing the
is
transportation.
anybody there from the forestry camp? Y'all hear anything?
Yeah, his caseworker.
Evidently, he's been revoked and we got him on a Class D felony charge. Is it y'all's responsibility to transport him under the order, or do you believe it's the sheriff's department down here? Which one?
I'm not sure on that. That would be our records department, but I can relay the messages to them to get in contact.
Okay, would you make sure what y'all's position is done on that, and his attorney will contact you maybe tomorrow or on Monday to see what y'all's position, so the transportation order will make sure that Mr. Miller gets transported down here. Okay, Mr. Miller, we'll try to straighten it out for you.
Yes,
Okay?
I'm ready to get this done and over with so I can get home.
Yeah, well, we'd like to do that also.
And Your Honor, as part of that order, since the negotiation conference and the pretrial is so close, would it be possible if I put on that he can be housed in Barron County during that interim?
I really can't direct where to house them.
Understood.
You know, I mean, they're a separate branch of government.
Yes, sir.
And, I don't know now, if if he decides to enter a plea,
We could do it by Zoom because he. can
well,
send it back.
or we might, where are we next week? Where? Nowhere. Nowhere.
Nowhere next week.
Well, I mean, we might pick a special day for him if y'all want to knock it out some way. if he's ready to move on. So you can, if you got the plea papers to him,
I've not,
Able to negotiate.
I've not negotiated with you. I'll look at what he's in being housed for and see what we need to do. Probably
yeah,
something.
well, if you want to fast forward it, it always, really makes my staff lawyer's job easier if you fast forward and get out of line.
If I get a counter offer, I'll be glad to entertain.
Okay, thank you very much. And Bell County, thank y'all for being so prompt and helpful on this, okay?
You're welcome.
Okay, y'all excuse, your attorney will be in contact with you, Mr. Miller.
Thank you.
Laurel County Detention Center, are y'all on there yet? Laurel County Detention Center. Okay, well, somebody see if they can get Laurel County Detention. Is that Laurel County Detention? Commonwealth versus Brian Elliott. I've got Brian Morgan's photo up. Who are you, sir, that has Brian Morgan?
No, sir, I'm Mr. Elliott's probation officer.
Okay. Okay, well, so we don't have Laurel County Detention Center up yet, so we'll contact them. Are you where you could call them and see if they're gonna appear by Zoom?
Sir, I talked to him about 10 minutes ago and they are aware of it and they said that he would be here at 11. So he should be on about any time.
Yeah, well, we're still a minute early, so I'm, we understand that. A lot of times these jails and you probation officers would like to go ahead and do something on time for occasion. You're not used to it. Courts letting you
Yes,
have
sir.
something on time, so you just keep monitoring that. And as soon as they get on, we'll handle your case, okay?
Thank you, sir.
Okay, let's go to Barron. Our Barron County is not on until 10:30. So let's just go off the record just a minute till we get Laurel County on, okay? Where do you need to turn me off? Right over here? I don't want to push the wrong button. Okay. This is Commonwealth Kentucky versus, Brian Elliott. Are you Brian Elliott?
The microphone's not on?
Somebody needs to turn the microphone on there at Laurel County Detention Center. It's a little red.
Yeah.
There you go. Are you Brian Elliott? Good morning, Mr. Elliott. Were you born in 1976?
Yes.
Last four digits of your social security in 1403.
Let's see.
Correct.
We're here on 19 CR 00123. What does the Commonwealth have to say about this case?
Your Honor, Mr. Elliott's on diversion of possession of controlled substance first degree has a 3-year sentence. He was almost off probation. I think he's had about 4 years in, and then the wheels came off. He had a drug test, had multiple substances. He wouldn't attend substance abuse treatment like he's supposed to. And he had an incident where the police was calling Laurel County where he had the drugs in his system. I can have Mr. Morgan testify if necessary.
I want to stipulate.
Your Honor, I was informed of this last night, so I don't know if my client wishes to stipulate or have a hearing on it. I'm prepared to go either way.
Well, we can put it off for a month if you want to.
Yeah, I was thinking if we got it stipulated to in final sentence, then we could probably address probation and treatment then, since he's almost had it done. But if he wants to put it off again.
Well, I'll tell you what, let's do. Let's hear the testimony from the probation and parole officer, and I'll give you more information. While you got it on, the officer, will you raise your right hand? Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Okay, state your name, and Mr. Stockton will ask you a question here about this.
Okay. Sir, it's Brian Morgan. I'm an officer with probation and parole.
Mr. Morgan, how long have you been supervising Mr. Elliott?
Since June of this year, he was actually on a lower level of supervision, and he was arrested, and we called him in for a drug test, and he tested positive for several different substances. We initially tried to place him in IOP. He didn't go. Claimed he didn't know anything about it. We turned around and they ended up giving him another chance. In between times, he was called to court. He didn't show up, and a failure to appear warrant was issued. He reported to me on August the 6th of this month, and we went ahead and served the warrant. He brought in a bottle of Suboxone dated from June of this year, claimed that was the current prescription. When he was in the office, he was pretty out of it. Speech was a little slurred. He didn't know who I was. He didn't know that he was on probation. He didn't know who had brought him to the office. We offered to go out and tell his transportation that he was going to jail. He gave about 4 different vehicle descriptions. When they got to jail, he was drug tested. He was positive for Suboxone. We did a Casper report, and he does not have a valid prescription for Suboxone.
But just to interrupt you, now this was on the August date that you're talking about, where he didn't know where he was and couldn't give you his transportation. Is that correct?
Yes. The previous mentioned positive tests were in June. He tested positive for 4 different types of benzodiazepines. Tested positive for marijuana. Tested positive for 2 different types of Suboxone.
Okay. I don't think I have anything else, Your Honor.
You have any inquiry, Mr. Carter?
No question, Your Honor.
Yeah. You still want to have an opportunity to meet with your client and come back next month, negotiation day maybe?
Yes, Your Honor, I believe that would be.
September, we'll set a negotiation date for September the 5th, and the next court date, September the 16th. Will you want a transportation order? You see, I don't know whether,
He's only in there for this old, I think.
That's correct.
Is he's not a state inmate. His diversion is actually still active. And he just lodged on a failure to appear warrant right now.
well, is he gonna be transported back down here or are they gonna continue to hold him in Laurel County?
Sir, that I don't know.
Is there anything holding him in Laurel County? I know he had
He
that
said
misdemeanor.
no.
He said no, okay. So I guess he should be in the Monroe, in the Bryan County Jail. Should be.
Judge, I'm good to be here the 16th. I have a medical procedure that's going to keep me out until that week, next week. So I won't be able to attend negotiation day. I'm confident.
Well, here's the problem that I've got on this guy here. He's only on a pretrial diversion. He didn't retain you till last night. Is that correct?
I was the original counsel on it, and I think that he didn't realize I'd been relieved sometime in the last 5 years. That's my theory. His dad came in last night.
Okay. I hate to put him off for 2 months before, he's sitting up there, they're gonna transport him back. He might need treatment. He might need a lot of things. I don't know what to do.
He said he could be here for the motion day, he just couldn't be there for the negotiation.
That's
Can
correct.
y'all negotiate on some other day?
But now he's gonna have to be revoked because otherwise his diversion won't expire. That's the problem we've got.
Okay.
But yeah, I'll be able to communicate with both sides before.
Okay, well, I'll just sit here on September the 16th and your attorney will be in contact with you to set up a negotiation day with the Commonwealth,
Do
okay?
we need to submit a transport order, Judge, or is that?
If you want him transported for that negotiation day at Mr. Stockton's office, you'll need to do that.
What about the court dates?
Yeah, you'll need to do one for that, but we don't know where he's gonna be. The order has to be directed toward where he's gonna be, and I don't know why he hadn't been transported back down here. If that's on,
I know it's big thing. Whatever you prefer.
All right.
okay, thank you, your attorney will be in contact with you, Mr. Elliott. Laurel County, thank you for your cooperation.
Thank you.
Yeah. Okay, Barron County, are you on there yet? Still a little early, still 11 minutes early, okay. Here you go. Which one of these buttons I push over?
The video and audio bonus.
So you stay.
You and I both got so.
I think.
Okay, let's go on the record here.
You know, do yourself on the screen. No. Okay.
Barron County, the first case is Alice Goodner. Monroe versus Alice Goodner. 22 CR 0048. Are you Alice Goodner?
Yes, Your
Were you born in 1961?
I sure was, sir. Yes, sir. Yes, Your Honor.
And the last four digits social security number 2567. Is that correct?
Yes, Your Honor.
You're here on 22 CR 0048 for probation revocation. What does the Commonwealth have to say?
Your Honor, Ms. Goodner has a 3-year sentence on possession of a controlled substance, first degree. She was initially pretrial diverted. She had a DUI and the diversion was revoked, but she was put on home incarceration. I believe she had a husband that was sick at that time. She stayed home to take care of it. And so now she's had a positive test for methamphetamines and opiates. She denied use, but it was confirmed by the lab that she was positive. And then that's the reason we filed. Said the probation officer wanted to explore treatment options, but since she denied use, we didn't. So that's where we are on the thing. I talked to the probation officer. I think she's agreeable if Ms. Goodner wanted to go into drug court, that we'd do that.
Okay.
Is that all right, Ms. Meredith? If we had that discussion yesterday?
Yes.
Mr. Bell?
That would be my suggestion.
You need to get over here where she can see you.
I would suggest that you do that. Is that something that you'd be all right with?
I sure will. Yes,
Okay.
Mr. Bell.
Okay, well, I will go ahead and sign a referral today to drug court and they will interview. It's going to take several days to get you in, but I'm agreeing. I'm agreeable to that.
Yeah.
Well,
Give me a call, Ken.
Do what? You want to admit, Kevin?
Yeah, she'll be in the Byron circuit over there.
Okay, we'll try to see if they'll admit you to the Barron and Metcalf drug court.
Can I ask a question? What does that mean? Can I be out with my husband, take care of him? Cause he's very sick.
I just asked the trigger just like everybody else does.
Yeah, we'll just have to go through the process. Why, does she live over there? Where do you live, man?
In Metcalf, in Metcalf.
So it would be more convenient for you to do the drug court over in Metcalf than here, right?
Yes, sir. Yes, Your Honor.
Okay, well, we'll go ahead and contact them to see if, and tell them what your situation is, see if they can advance it, okay? Thank you.
Thank you, good.
Thank you. God bless you, Your Honor.
Yeah, thank you. Samuel Graham. Are you Samuel Graham?
Yes, sir.
Good morning. This is 25 CR 0039 for arraignment. Mr. Graham, were you born in 1977?
I was.
Last four digits of your social security number 6219.
Yes, sir.
Your attorney is here today, and you're here for the purpose of arraignment. You have the right to remain silent. Okay, the grand jury of Monroe County's returned an indictment charging you with criminal trespass in the 3rd degree and possession of controlled substance methamphetamine. Do you understand those charges? I'm not asking whether you did or not, but you understand the charges?
Yes, sir.
Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all your pretrial motions? Do you do that?
Yes, sir.
Okay, I'm signing, Mr. Graham, I'm signing a reciprocal discovery order that will require the Commonwealth to provide your attorney with information that they have that's discoverable that will help you prepare your case. We'll schedule you for a pretrial for a negotiation day, however, on September the 5th. And your next court date is Tuesday, September the 16th. Now, what's he charged with, a drug charge? Is that what it is? What's his
Assault
bond?
third, Your
He
Honor.
has a no.
It's a assault third.
He has appendix. We have a cell that's got there, been waiting to the grand jury.
What kind of case is that?
Violating graves, 17 counts of criminal mischief in the second degree.
We had a prelim already, so it's just waiting on grand jury indictment.
Okay, well, if you want a bond reduction, then you'll need to file a motion on it, okay? Okay, thank you very much.
Thank you.
Your attorney will be over to see. Mark Hunter. Mark Hunter. Are you Mark Hunter?
Yes, sir.
Good morning. This is 2019 CR 00114, 22 CR 0053, and 25 CR 0032. The first two cases are for shock probation revocations. And the third case, 25 CR 0032, is here for a pretrial conference. Y'all reached a resolution of that case?
Your Honor, that's a sex abuse case, serious charges. We've got to get the BRAC interview and look at it ourselves and furnish it to council and we get an order entered. So I'd ask for a pretrial conference in October and do the October.
What's the negotiation date in October?
It's the first Friday. It's
So the third, Your Honor?
third.
October 3rd for negotiation day, and the next court appearance is October 16th. Both of them are conditions of bond. Okay, your attorney will be over to talk to you as the process continues, okay?
Thank you.
Garvis Morris. Garvis Morris. Are you Garvis Morris?
Yes, Your Honor.
Good morning.
morning.
25 CR 0038. Mr. Morris, were you born in 1970?
That's the one we're talking about.
Yes, sir.
Last four digits of your social security number, 0839.
Yes, Your Honor.
Here today for the purpose of arraignment. You have a right to remain silent. The grand jury of Monroe County has charged you with alcohol intoxication, disorderly conduct, resisting arrest, and assault third degree. You understand those charges?
Yes, Your Honor.
Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions? We'll set a negotiation. I'm going to sign a reciprocal discovery order here. Mr. Morris, that requires the Commonwealth to provide your attorney with information to help prepare for the defense. A negotiation date on September 5th. And the next court date's on Tuesday, September 16th. And you'll need to do transportation orders for your clients for both those days, okay?
Yes, sir.
Okay, your attorney will be over to talk to you, Mr. Morris, okay?
All right, thank you.
Okay, Michael Turner. Commonwealth versus Michael Turner. Okay. You're Michael Turner. This is 23 CR 0055. Mr. Turner, as we know, was born in 1967, and the last four digits of his social security number are 1161. What do we have here?
Yes, Your Honor. We're working with the county attorney's office to get a guardianship filed on Mr. Turner. So hopefully that will be filed either,
Mr. Bruce Brown
The
is
next few
online
days.
here, is appearing.
but
So you're
that's
gonna get in Barron County to have a guardianship?
be filed in Monroe County since he was a Monroe County resident. Yeah.
Well, that's always a bone of contention over in Cumberland County, where they get filed in Adair County or Cumberland County. I don't know, have we ever addressed that issue, which is the appropriate jurisdiction to do it?
No, but I mean, his permanent residency before he went to jail would have been in Monroe County.
Well,
So
and when people are at Eddyville or LaGrange or all those places, they all have them there.
yeah,
So, Mr. Brown, are you amenable to having it? Are you gonna represent him in that?
Unless I'm appointed, no. But I don't know what the process is for that.
Well, I don't,
they'll appoint someone to represent him, and then if he,
yeah, his guardianship, the guardian ad litem will be appointed. Are you on the guardian ad litem list over here?
I'm not in Monroe County, no, Judge.
Would you like to be? I think it would be probably the scale of economy if you would represent him in that. So I'm going to appoint you to represent him in that. And if you want to turn down the appointment, I understand. Would you rather get somebody over here to do it?
That would be my preference, Judge.
Okay, well, I'll do that. You're fired. Who's on the list next year? Well, whoever's on the list next year, we'll appoint them as guardian ad litem and they'll go over and interview Mr. Turner. Okay, is there anyone else there in the Barron County Jail?
That's all we have, Judge.
Okay, thank y'all very much for your cooperation.
What's the deal here?
Wait.
Skip Herschel.
Herschel Hammer. Commonwealth versus Herschel Hammer. 23 CR 0083 and 24 CR 0025. Mr. Hammer, were you born in 2005?
Yes, sir.
Last four digits, your social security number 5631.
Yes, sir.
Okay, what do we have here? Shock probation motion. Okay. You want to present it?
Because I need to.
Was he today or next month?
No, on shock probation motion?
No, it's a motion to vote, Sheriff.
Okay.
Judge, I was just retained in this case. He has some cases pending in Barron and Metcalf. I'd like to have a negotiation day to see if we might.
Negotiation day on September 5th. Next court appearance is on Tuesday, September the 16th.
Thank you, Judge.
Okay, thank you. Your attorney will be over to talk to you.
Shoot some fish.
Okay, that concludes our business. Thank y'all for your cooperation, Barron County.
Thank you.
Yeah. Okay, I guess we're off until 11 o'clock.
Judge Jackie Williams presiding.
Thank you. Everybody have a seat. Okay, we'll go to the child support docket. Hello, how are y'all today?
Good, how are you?
Blessed, blessed, blessed. Clary versus Clary.
Could you swear Ms. Staples in, please?
Swear the testimony that you're about to give is the truth, whole truth, nothing but the truth.
Last one.
Yes.
Temp order. State your name for the record, please.
Taylor Staples.
You're familiar with Monroe Circuit Court Case Number 17 CI 177 versus Melina Clary, is that correct?
Yes.
There was a contempt order entered on July 17, 2025. Has Ms. Clary made any attempt to purge herself of contempt?
No.
Not contacted our office, made any payments?
No.
As far as you're aware, she's still an able-bodied person capable of providing support. She's neither incarcerated nor a member of the armed forces. Is that
I
correct?
can't hardly hear you, I'm sorry.
I'm sorry. I'll try to speak.
Correct.
Wait, just get around behind the directional.
She
microphone.
is, as far as you're aware, an able-bodied person capable of providing the support. She's neither incarcerated nor a member of the armed forces. Is that correct?
Correct.
Judge, we'd ask for a bench warrant.
Okay, what she have to do to purge herself?
We'd ask that she make a lump sum payment of, I forget what the order said. I think it was $1,000, but she's not made any payment.
Great. Crawford versus Crawford.
Continue to
September 6th.
September 16th, please.
Okay. Comer versus Comer.
Ms. Staples, you're still under oath. You're familiar with Monroe Circuit Court Case Number 21 CI 44, Commonwealth of Kentucky versus Jeffrey Comer. Is that correct?
Yes.
Mr. Comer has an arrearage of $817.20. There was an order of contempt entered on July 17th, and he has done nothing to purge himself of that contempt. Is that correct?
Correct.
And as far as you're aware, he's still an able-bodied person capable of providing support as previously ordered. He's neither incarcerated nor a member of the armed forces. Is that correct?
Yes.
Okay,
Judge,
submit
we'd ask
the
for a
order.
bench warrant.
Russell versus Curtis, 20 CI 00128.
Continue to September the 16th, please.
Donaldson versus Donaldson, 12.
That's just our motion to intervene is on behalf of the child support office so that we can be made to pay and oversee the collection of this amount.
Okay, thank you. Fox versus Fox.
Continue to September 16th, please. It's at $3,845.
That's the oldest case I have left. 13 years was my first case this year. Graves versus Graves.
Continue to September the 16th, please.
Turner versus Guffey.
Continue to September the 16th, please.
Hammer versus Hammer.
Ms. Staples, you're still under oath. You're familiar with Monroe Circuit Court Case Number 18 CI 118, Commonwealth, Kentucky versus David Hammer. Is that correct?
Yes.
Mr. Hammer has an arrearage of 13,438.56, and there was an order of contempt entered on July 17th, and he's not made any effort to purge himself of that contempt. Is that correct?
Correct.
And as far as you're aware, he's still an able-bodied person capable of providing the support as previously ordered. He's neither incarcerated nor a member of the armed forces.
Correct.
Ask for a bench warrant.
One will issue.
Thank you.
Hasted versus Hasted.
Continue to September 16th.
Did I get the pronunciation right?
I've never met these people, so I don't.
Well, then there's no one to take issue with.
Yes.
Taylor versus Houchins.
Continue to September 16th, please.
Hudson versus Hudson.
Continue to September 16th, please.
Jimenez versus Jimenez.
Continue to September 16th, please.
I nailed that one, right?
You've got it.
Okay.
We're working on the first name still.
Yeah, well, Joyner versus Joyner.
Ms. Staples, you're still under oath. You're familiar with Monroe Circuit Court Case Number 16 CI 79, Commonwealth versus Kenneth Joyner. Is that correct?
Correct.
There was a contempt order entered on July 17th. Mr. Joyner's made no efforts to purge himself of contempt. Is that correct?
Correct.
As far as you're aware, he's still an able-bodied person capable of providing the support. He's neither incarcerated nor a member of the armed forces. Is that correct?
Yes.
And as of today, he has an arrears of 27,341.13. Is that correct?
Yes.
That's for a bench warrant.
With that, it will be entered. Dye versus Jones.
Continue to September 16th, please.
Jones versus Jones.
September the 16th, please.
Page versus Page.
September the 16th, please.
Pennington versus Pennington.
September the 16th, please.
Rich versus Rich.
September the 16th, please.
Smith versus Smith.
September the 16th, please.
Okay, are y'all gonna be over at the River Vestas? Well, must be something very important for a hog wild not to be at the River Festas.
They haven't told me if they are.
Yeah, okay.
I've got my split the pot.
You gonna come over?
No.
Okay, Capshaw versus Capshaw. Excuse me.
Good afternoon, Your Honor.
Hello, how are y'all doing? Oh,
Your Honor, this is my motion under UCCJEA for the court to communicate with the court in Tennessee. There are competing claims, competing actions filed. And as I understand the statute I've cited 403828, the judges should communicate about which court is the most proper jurisdiction.
I received a call today from Judge Jimmy White, and he had it's not the commissioner or something from
Chancellor.
He had the chancellor from Cookville on the line, and we have had a discussion about that. And they sent me his number, and I'm supposed to communicate with him. But before I do that, in detail, I didn't want to make any decision. I had an opportunity. He says that there are documents that have filed that are sworn statements by both parties. That both parties have sworn that they lived in Tennessee for 2 years, and it's a record, and he wants to keep it down there. So what do you?
He's indicating to me that whatever he signed said he had lived there for 2 months. Their marriage was not, they only lived together as a married couple for about 2 months before they separated, Judge. They did live in Tennessee during that period of time, but he immediately relocated back to Kentucky upon their separation. I think they were married in August and separated in October. So we filed the petition for dissolution here first in time.
Is your child involved?
Yes, the child is, but of course, the child's a newborn, so the child technically hasn't lived anywhere, hadn't moved anywhere for 6 months at the time that we filed the petitions, because she was pregnant, obviously.
Well,
most of the
if I could
separation.
just briefly respond to that. I agree with Ms. Coleman. They were married in August, separated in October. At that time, they resided in Tennessee. Mr. Capshaw filed his petition here on April the 21st. My client filed in Tennessee 2 days later. The child was born April 30th in Tennessee. And under UCCJEA, if there's a child less than 6 months, the home state under the statute is where has the child resided since the date of birth. And the child has resided exclusively in Tennessee.
Well, that's what.
And Judge, I guess my response to that would be there was no child at the time of the filing of the petitions. Again, ours was first in time. I would also remind the court that we were here a couple of months ago on our motion regarding temporary visitation because he wasn't getting to see the child. And both parties were here, represented by counsel, and Ms. Capshaw agreed on the record for Kentucky to hear the case. And then a matter of days later, I guess, had buyer's remorse and filed in Tennessee saying, no, we still want it in Tennessee. I also would say that there
What do
are
you-
exceptions.
What do you say about that?
What I say about that, Your Honor, is she
Who-
did not,
Who represented her here?
Mr. Stevens. She thought she had to enter into some agreement on temporary visitation. This was a child that was at that time.
But did she agree? I know, but I'm not talking about the visitation. Did she waive and agree to have it heard in
Well,
Kentucky on the
the
record?
order prepared by Ms. Colvin said she waived jurisdiction. My position to the court is, and what I think the law is, you cannot waive subject matter jurisdiction. And the case law is pretty clear on that. There's some cases in Kentucky, Duncan versus Onan, which it was a will contest, but the court said there it is elementary principle. You cannot waive subject matter jurisdiction.
I've been on the wrong side of that a few times.
And under UCCJEA, the principal question of jurisdiction is what is the home state of the child?
What's the problem? The Tennessee court wants to keep this. Told me that he was reluctant to keep anything that he usually, but that he felt so strongly about this, the Chancery court felt so strongly about this that he said just couldn't allow that to happen, you know. What do you have to say about his argument that you can't waive subject matter jurisdiction?
Judge, I would have to research that, but I also know under the UCCJEA, there are the home state of the child can be determined in different ways. Some of the exceptions include the substantial connections in other jurisdictions. Both of them had resided in Kentucky. Their extended families reside here in Monroe County, Kentucky. Her business is incorporated in Kentucky. And
well, the Chancery court is located over in Cookville. I don't really think there's a very big chance of him getting hometowned, you know, over in Salina. If I thought that someone was trying to pull a switchy in there, I mean, because it's kind of like living in Metcalfe County and having all your judges come over from Barron County, except the districts are larger. I mean, Cookville's a huge metropolitan area, and I can't imagine that there would be any prejudice to your client by having it down there. What prejudice would there be to it?
I think one of his concerns is that in essence, Ms. Capshaw's forum shopping, what she's asked for in Tennessee is 365 days of the year with the child. And Tennessee law is not the same as Kentucky law. Kentucky law is
It's a
much more
presumption,
equitable when
50-50.
it comes to co-parenting than Tennessee is at this point. So he is very concerned of the position that she has taken down there.
Let me ask you something, Mr. Hoover. Is there any chance that these people can come to accord on this thing? If they came to accord on it, it wouldn't matter what state it was in.
I don't think right now there is, Your Honor.
Well, if it isn't right now, it won't get any better because, I mean, are there allegations of, what kind of allegations are against this man?
In all fairness, Your Honor, there are no allegations specifically against him. However, he lives with his father here in Monroe County, who is a convicted sex offender.
Is that true?
Yes, Your Honor.
Oh,
She knew about that before we got together.
well, yeah, she might have known that was before you had a baby too, you know?
And he is sending her photos with his father holding the child.
Yeah.
Judge, she agreed to a temporary schedule of visitation. She
Again,
did not ask for a restriction in that agreement. That
I
the
didn't
father
know
not be
about
around.
it. Nobody brought it up to me.
Again,
You
Your
know.
Honor, she thought she had no choice that day here but to enter into some
Who
agreement.
represented her that day?
Mr. Stevens, Wesley.
Yeah.
Your Honor, I just would like to reply very briefly to Ms. Coleman's about the home state. Under the UCCJEA, jurisdiction is primarily based on the home state of the child. Tennessee Code and KRS 403-822 defines home state for child less than 6 months where the child has lived since birth. And the child has undisputedly lived in Tennessee since birth.
Judge, I would object to that. The parties have been.
What kind of business does she have incorporated here?
She has like a coffee, it's a mobile business, coffee, baked goods, that type of thing. She sets up at different places. She's licensed in the state of
Did you want to
Tennessee.
respond to that last statement before the coffee bit?
I did, Judge. The second that child was born, they are married. They had a child in wedlock. That child was they were joint custodians. So I don't know that you can argue that the child lived in Tennessee as much as the child lived in Kentucky. Technically, the child lived with either and both parents. They're joint custodians by default, by definition of law.
I disagree with that. Under
Just
the
because she wouldn't
definition,
let him have the child physically and he had to come to court to try to get time with the child, that feels unnecessarily prejudicial against my client that she could manipulate the system, withhold the child, and then use that to claim that's the home state.
Judge, the child was born after he filed his petition. And the child was born in Tennessee on April 30th, 9 days after he filed his petition. Obviously, they were filing it, trying to get Kentucky to assume jurisdiction before the child was born. But under the UCCJEA, the definition of the home state is the primary determining factor of jurisdiction and the home state for a child less than 6 months, where has the child lived since birth? It's Tennessee.
Did you file a written response to this yet?
No, Judge, I thought this was just a motion for you to speak with the judge in Tennessee. So I guess I extrapolated that
That's
there
what
would
it
be.
is to me, speaking Judge Tennessee, but
I mean, we don't have an objection to you speaking to the judge down
I
there,
already
so,
spoke to him.
right.
You know, but I didn't initiate the contact. The contact was initiated through the help of Judge White. And thing about it is that I was looking to see, he was supposed to send me his contact information by text.
It's in the motion, Your Honor, I filed.
Yeah, but he gave you his cell phone?
Oh, I don't have that.
Okay. I was gonna say, thought I was the only person, everybody had their cell phone. I'll tell you what I'm gonna do, is I'm gonna give you an opportunity to file a response to the technical aspects of the code. I don't frequently handle these things. I think in 13 years, I might have had 4 of them, and it's unusual just to have 4 of them, but quite frequently, if you live in Burkesville, most people in Salina and Clay County had rather have it dealt with in Burkesville than they had somebody from Cookville come over, you know, I mean, that sort of thing. And, you know, I don't know, I'm gonna give you like 10 days to do a response.
Sure.
And, you know, the chancellor felt pretty strongly about it. I'm going to tell him about this this thing here. And if you want to put something on record by your client while we were here about their living conditions, I mean, it appears to me that were they married, was the marriage consummated in Tennessee? They get married in Tennessee? Where did they get married? Tennessee?
They got married here.
Did they have a Tennessee license or what?
They got married here in Kentucky.
Okay, and they got married here in Kentucky. Where were they living when they got married?
They were
Tennessee.
living in Crossville when they got married.
Well, that's unusual. All
I think
my
Americans-
early practice was, where are you at? Birdtown, Pickett County, Tennessee. Where'd you get married? Because they did, at that time, back in the olden days, you didn't have to have blood tests for venereal diseases. So people went from Kentucky down to Tennessee because they get married the same day and they were all in a hurry.
Yeah, Judge, I think that was because families on both sides, all the extended family lives here.
Yeah. Okay, well, I will, now, your family lives here also?
I was born and graduated from Tennessee.
Graduated,
I was homeschooled, but we went to a co-op over there. They have all my like records of my schooling.
yeah,
We live right over the line into Tennessee.
yeah.
And I also would like to say that I was having Micah, the baby, visitation every time Michael asked. Multiple times.
Well, just parenthetically, just for what did your client have in mind about what fair visitation? Now, they say that they're trying to drag them down into the orange state so that she'll have some kind of advantage of law and that sort of stuff. I mean, the law really doesn't matter if an agreement as to permanent visitation and joint custody was held. It would appear to me that it might reflect upon her intent. If she's not willing to even talk about it, want to take it back down there. Are you licensed in Tennessee?
No, nor do I want to be.
Yeah. I never was licensed in Tennessee either, so.
Yeah, I'm not sure what her intent is. Quite honestly, I have only talked with her about this motion. She's represented by an attorney, Dana Looper in Cookville, who she has had the discussions about visitation and arrangements and things. I've not really discussed that with her.
Okay, give me your response to this. And, you know, it appears to me that your response will be based upon definitional, factual definitions as to how you apply some of these things. It look like the law is pretty clear and on the thing. So why don't you hang in there with the law as much as you can? And would you like some time to respond to that also?
7 days, please.
7 days, or 10 days and 7 days, and that'll get us back up here. And I might very well enter an order one way or the other. And I'm gonna get a hold of the chancellor down there and tell him that there was some factual disagreements. And I don't know whether to take some testimony today. They got affidavits one way or the other. I don't know. Is there?
Don't think any testimony is necessary, at least from my standpoint.
Yeah, I don't think, it appears that they pretty much agree with the times and dates of marriage and that sort of thing, where they lived and that sort of thing. So, well, I appreciate, I'm sorry that I'm not more knowledgeable on the UCCJEA, but it usually is that people call me up from Texas and tell me that they're more than willing to have that case heard in Cumberland County, or I'm called the judge in Texas and the people really don't care one way or the other. So is there anything else you'd like to say about it?
Just respond to one thing that Ms. Capshaw said, and she said she allowed him to see the child from birth. It had to be at her place with her supervising. We had to come to court to get time away from her with the child. So I'm, like I said,
Well,
I'll
I'm
just
sure that she-
reiterate my concerns. And my client works, he travels through the week, so he's not even asking for 50-50. He recognizes that's an impossibility.
What is he asking for?
I think weekends, probably 3 out of the 4 weekends out of the month, until the child's school age and involved in activities or
Well, would you
something.
consider every other weekend? Okay, well, then you're probably gonna have a hearing somewhere. That was a quick no. So I don't blame you. You know, you gotta, there's a presumption you get 50-50 up here, but the presumption is fairly easily overcome. You know, with factors is, you know, I mean, people think it's automatic a lock, you know, but if you're gone all the time.
And like I said, that's why he's not even asking for that. And that's what's alarming and concerning to us, that there's not even any openness to conversation to something that's not even anywhere close to the standard.
Yeah,
And then
It
the way that
concerns me-
she,
it
the way she
concerns
filed her
me
pleadings in
somewhat,
Tennessee,
too.
asking for the 365 days of the years, it's just concerning.
you know, and the thing about it is, even if I agree to this, an appellate court might very well rule that I'm wrong. He won the race to the courthouse, and it could go to an appellate court. It'd be interesting to see where the appeal has to take place. It might have to take place in federal court. I don't know. Where's the appeal take place on a decision on one of these things? It's a federal statute.
Yeah, I'm not sure.
You know.
I would think Kentucky Appellate Court.
Well-
simply because there's a lot of decisions regarding UCCJEA
Yeah.
in state courts, but I don't know. That'd just be my guess.
All right, well, I guess they could appeal it in Tennessee State Court too, if there was a ruling. So I'll talk to the chancellor and tell him what I've done, and then forward the pleadings to him before he and I have a talk, okay?
Okay.
Thank y'all very much, yeah. Okay, Stinson versus Graves. Now, are you involved in this case? Yeah,
Good to see you. My big excuse.
sure,
Thank you.
yeah. Give me a call sometime. Good seeing you, yeah.
Thank you.
You might step out there and tell her your case has been called, okay? I've called Stinson versus Graves, and we understand that we got a COVID problem here. Is that correct? I thought we had all that behind us, you know.
Oh, and he wanted to communicate yesterday with me about it, but I was trying to get my son settled into his dorm, so it just didn't happen before here, so. But my understanding is he was just gonna ask for another date for hearing on his motion.
Okay. And this was to suspend parenting time?
Yes.
Why did you want to suspend parenting time?
The motion, the contents of the motion, are they wanting to suspend parenting time because his mother has been charged criminally?
Was there anything other than that?
No.
Yeah.
And I mean, they've continued with what the agreement is up until now. And part of the agreement right now is expressly that the moms, he's agreed every step of the way that mom not be involved in the visits.
Okay. Well, y'all renotice this, or you gonna renotice it next month, or what are you gonna do?
Is Mr. Wilson on Zoom? No,
No, he's not on.
it's his motion, so it's kind of up to him. I think your September date, I think we've already be on.
September 16th.
I kind of think we might already.
Tuesday instead of Thursday.
I know. I think we might actually already be on that day, just for a review on where we were with the temporary visits.
Okay. Okay, well, we'll continue it to that day unless he wants to try to refile. It was filed as an ex parte motion. I don't do very many of those unless it's a pretty strong sort of situation. Okay, well, thank you very much. Is this one that can be worked out between you and the lawyer before?
We've tried, Judge, we have tried, and Mr. Wilson has in good faith tried. I think that there's just,
After a while,
there's a gap between.
we have all these cases that can't be worked out and you're involved in all of them. You know.
I don't know how I feel about that.
It
I
reminds
think I'm
me of-
very amenable and
It
easy to work
reminds, not
with.
that I'm applying this to you, but there was an old Amish guy one time that told his wife, said, everybody's crazy but thee and me, and sometimes I wonder about thee. So, I don't know, just, I know that's not apropos here, so I'll wait. for
I'll
y'all
reach
to-
out to Mr. Wilson and we'll try again.
Okay, thank you.
But
Thank
yeah,
you. And the next one is Milam, you can go.
it's the same, companion case.
Yeah. That's.
They're both, yeah. So
Okay,
just-
so both of them will be continued subject to that, and if there's something, we understand that illness happens, if there's something that needs to be heard before that next time, or his clients really feel strongly about, I'll make sure that we work with y'all to get something
I know Ms.
scheduled.
Thompson had asked us about available dates in August. I don't know if Mr. Wilson had responded to that message or not, but I'm happy to work something out.
Yeah.
We can just do that through
You
email
know,
with her if we need to.
getting dates with availability for lawyers is like the bane of her existence, I mean,
I'm sure.
sometimes we
I'm
just have
sure.
to go ahead.
Yes.
Okay, well, thank you very much.
Thank you, Judge.
Green versus Green. I assume that you are representing Michelle.
Yes, sir.
Michelle Christine or Kristen?
Christine.
Christine Green. And where is Anthony Douglas Green?
He's in jail. Oh, I was gonna say, he was just charged again, a couple of days ago for violating the EPO.
Okay, well, he'll need a guardian ad litem appointed then, correct?
I guess, well,
He's incarcerated.
sure. I mean, we just have a motion asking that he be drug tested and have a mental health
Well,
assessment.
He can't be here, and he's
Right.
incarcerated, so, what's
And I
happening?
don't know if he was appointed, he may have been appointed one, the original EPO was filed here in Monroe County. Now, there have been violations filed in other counties since then, but I don't know if he had a
Would you
GAL
check
in
on
that
that
case.
EPO for me? Gentleman's name is Anthony Douglas Green.
What do you want to know about it?
There's an
He had a
EPO
GAL?
filed here, and is he gonna be incarcerated for a while, or what?
He has Monroe County and Metcalfe County charges for violation of the EPO.
And
He
you're,
was out on bond when he alleged to have violated in Metcalfe.
so it's gonna be criminally
Yes.
prosecuted.
He had criminal prosecutions pending in Monroe and Metcalfe.
They found him on an ankle bracelet.
Yeah,
Did he have a GAL though, Wes, in the EPO? Do you
No
know?
bond? Okay, well, I'm gonna appoint him a guardian ad litem and, probably the EPOs have suspended any visitation right now. And is the county attorney's office involved in this?
Yes.
Well, I would like, for you to say that we're going along with the interim order that says, for now, we're going along with the district court's order on this situation. I don't know whether the EPOs will be pulled up here or not, because we've got a case here. I mean, why weren't they pulled up here? But it was because there's a criminal violation. I was wondering if it was a violation of an EPO, why it didn't come, and now I know. Okay, because there's criminal charge. So, what we will do is that we will recognize the bond that has been set there, and until those are rectified, those criminal cases are rectified, we will hold this in abeyance, this case in abeyance. And the other problem we got is we got the Metcalfe County violation, but that's a violation of a Monroe County EPO, right?
That's correct.
Correct,
Okay.
Judge.
And Mr. Richardson was the one who had him on the ankle monitor.
Yeah. Okay, so the deal is here is we'll have to wait to see how the criminal charges are in both counties. It sounds like that we'll probably be seeing this at some juncture anyway, because is it a misdemeanor charge that they have? Misdemeanor, so I won't be seeing it unless I see it on appeal. Okay, well, we'll just hold an abeyance on this thing. I don't know whether I can really, I'll appoint a guardian ad litem to go interview him on this particular motion here, because it appears that it goes farther than an order could go on a criminal charge, as far as asking for drug screening and mental health assessment. Because he might have some, if he's incarcerated, I'm just thinking out loud, if he's incarcerated, he would probably have some self-incrimination sort of things on previous actions as far as a mental health assessment. It would probably could refuse to answer because it might incriminate something. You'd have to go into factual situations about the underlying crimes. So I will appoint a guardian ad litem. Let's redocket this for next month, September 16th, to see if he's developed on the criminal cases.
Okay. Judge, what time do you want me to set that for?
Well, it's, what do we usually do, 1:30 or 1 o'clock? 1 o'clock, 1:30. Okay, thank y'all very much.
Judge.
Heilman versus Heilman. Continued to when? September 16th. 16 CI 0091. Motion for summary judgment. Uh-oh. Something's about to be sold here. Maybe. The master commissioner coming up here, kind of sliding up in the edge. Okay, this is amended motion for summary judgment on the defendant's first counterclaim. What do you have?
Your Honor, our original motion for summary
You have to
was,
speak up a little bit if you don't mind.
our original motion for summary was argued in 2023. The court took it under advisement, suggested we continue to try to work it out. Nothing ever got worked out.
Seems to be an epidemic of that here.
Ms. Coleman's not in this case.
Well, that is true. But Your Honor, there have been several attorneys involved in this over the years. And I think Bobby Richardson was representing, were you representing the estate at the time, or was Mr. Richardson?
Give me a renewed, I read through this thing, but it's a little convoluted for me to follow.
There was a plat that everybody agreed to.
Oh, yeah.
And then it was recorded. And then.
Is this the tree line deal here?
No.
Good.
That case, there was not an appeal filed, so. Time has run, so.
So on this one, Your Honor, after the plat was recorded, there was a settlement agreement.
Let's get back to the basic underlying fact of the thing. You want to tell me you know what the underlying fact that was on the case?
No, Your Honor, I've come in and I represent the estate after Mr. Kruger has passed away. And so to my knowledge.
What did the plat accomplish? I mean, what was it trying to accomplish? A division of property between?
It was a property line. It was also regarding water line easement and access easement, and that's why Mr. Stevens is here. The reason Ms. Brown is here is because Mr. Kruger signed a settlement agreement, which is part of the record in this case, and he was supposed to transfer some land to my clients. He then went and sold the land. Several years ago, we did some interrogatories and requests for admissions. He admitted that basically he signed the agreement, he did all these things, and then he broke the agreement. He admitted to all of this. And then as the final answer, he raises for the first time some 6 years, 7 years after the case is filed, he raises an affirmative defense saying that he had been forced to do this. And that was the first time this affirmative defense was ever raised. And actually has not been pled in any of the pleadings.
Okay, you're talking about pleadings and stuff. Just get right down to the basic facts of this thing, okay? These people, were they related to each other? Or what, was there a water, tell me about the water line and why the agreement was signed again, okay?
The main reason that the agreement was signed was the litigation was regarding property lines and access.
I know that, but tell me some facts about this property dispute.
The main concern is access, Your Honor.
Access to what? I'm not learning anything.
To my client's land.
Okay.
We have to cross Mr. Stevens' client's property for a very short distance. Everybody thought it was a public road. The road department came down, they marked the end of the road. It didn't come to our property. This is when Mr. Kruger owned the property. So this lawsuit was filed to settle these issues, to give us access.
What about the water line thing that you're talking about?
It's ancillary, Your Honor, but there is a water meter that my clients felt like probably was on them, and it was placed and it wasn't on them.
Does it deny them access to water now? Or?
They've not been denied anything. They're trying to clarify the ownership and their rights.
Have they been denied access to their property?
No.
Okay.
My client bought the property from Kruger. There was a plat recorded. Mr. Basil asked us to give up more than what the plat showed.
That true?
His clients.
I know you wouldn't do that personally. You retract that, don't you?
I think there's some question about that, but I certainly understand Mr. Stevens' argument.
Yeah.
There is.
You offered him an easement across the property?
We've had no problem with that. It shows on the plat that it's a road.
We're just asking for a judgment that says we in fact have the right, not just at her will, but we have the right.
Well, what you want a right of an easement is what you want.
Exactly.
Easement. Do your clients have any problem with giving them an easement to end this thing?
Well, that will end my client's part of it. It has nothing to do with the Kruger estate. Because there was an argument about the water line and
what other redress of the grievance besides an easement to the road and to the water line did your client want?
My client, at first, we were talking about easement, and then they wanted ownership of the road. And that's where Mr. Stevens said.
What's the difference as far as the benefit of your client if they have a complete easement across it that's defined, the width, the maintenance of it, that sort of thing? What's the difference?
My client just told me they wanted to.
I'm asking you to explain to me what the legal difference as far as what might impact them might be, I mean, if they have an easement to get to water, they have an easement across the road. Do they want it to be made a county road and dedicated at some time? Is that why they're interested in having ownership of it?
I think that plays into it.
Mr. Stevens, does your client have land on both sides of that road?
Yes.
Well, you can understand why somebody wouldn't want to give a deed up to the thing.
It's a well-defined, well-traveled roadway. We've never made a claim of exclusive ownership, barred anybody from coming across it.
Well, I understand why they would want your client, some future owner not to be able to do that. You know, you usually, as they say, somebody comes in here and buys some land and ain't from here. First thing they want to do is there's no written easement, there's no.
Do you have a copy of the plat?
Yes. It's a bit travel worn, but
To help, here is,
Well, let's put it up on the screen over there. Can we?
I don't know about very well. Technology.
Yes.
He's got.
both for the water lines, for the utilities, and for the roadway.
Well, can you prepare an agreed order to that effect? Get your clients to sign?
Yes.
Okay, well, let me tell you something. You get an agreed order and circulate it to the other parties and see if it's agreeable in this lawsuit. As far as I'm concerned, we'll go as far as it's gonna go, and if you want to seek damages to somebody, the person that sold it off after you done the agreement doesn't own it anymore, right? Doesn't own anything anywhere anymore, correct?
They are seeking damages against him for
Well,
having breached
okay,
his agreement.
I'm telling you, you could still proceed with that. It's, and get the underlying issue that's the main portion. It might very well be that you have something you can take in a jury as far as damages, but the primary purpose is resolved with this easement, and then you could look to see if it diminished the value of your property, and maybe a jury can decide that.
But my client would be out.
Your client would be out, and your client would be protected as far as having an agreed upon judgment, an agreed judgment in order, which could be placed in the record books that indicate the extent of the right of way across there. And it needs to addition that there's previously been ruled as a public passageway, but that the parties agree that there's a right of way across it.
And my client is on Zoom if you have any questions for them.
Well, I don't have any question for them. You're representing them. Now, that wouldn't keep them from proceeding against the party that they aggrieved that is damaged, diminished the value of their property and they're damaged.
And that's the other part of it.
Do you represent that party?
Yes, Your Honor, I represent the estate of Mr. Kruger, and I have filed for a motion for summary judgment as well, which states that we've attempted to resolve this on several occasions for a long period of time. We'd love to settle it.
Did you offer them money?
Yeah.
Yeah. Well, you know, what would, when people won't take money and they won't take resolve, I want to resolve this other part of it. And then, you know, you want a jury trial or you want to try it in front of me? Let's just set up a jury trial on it. I can set you one pretty quick. We'll just, as my old law professor used to say, we'll let them lay where Jesus flings them. You know, and they might not get a dime, but they might get more. What was the basis for the summary judgment motion? I didn't.
My basis for the motion for summary judgment was that the original cause of action was filed before that settlement agreement was signed, that, you know, their argument that was in violation of the statute of frauds. They didn't have a contract related to that deal between them, related to the transfer of the land. And so after they did get their settlement agreement signed, they're seeking to enforce that settlement agreement in the terms of breach there. Well, he did sign an affidavit on the record, which states that he signed that under coercion and duress. And so,
Well, that seems like a factual question to me.
well, if he asserts that there are no genuine disputes of material fact, and that fact is on the record, then there are no disputes of material fact. He concedes that fact is true.
Your Honor,
Who's he now?
Mr. Kruger, claimed coercion in 2021, 5 years after this was filed. It's an affirmative defense. It's not something that you casually raise.
Did your client, you represent?
Average.
Did your client acknowledge that there was coercion?
They did not, Your Honor. I'm saying there's
See, I mean, it's not an established fact that there was coercion. What do you say to that? Your party alleged that it was coerced. Might have been.
Yeah,
Who coerced it? Who coerced
alleged
it?
that there was coercion, but now Mr. Kruger is no longer here to defend.
Yeah, but who coerced him? Who did he allege coerced him?
Average LLC.
And because that's an affirmative defense, we're claiming that that defense was waived because it was not.
Brought in time. And what do you say about that?
I do agree that it is an affirmative defense, Your Honor. I wasn't a party to this back during that time, but such a long period has lapsed. Mr. Kruger.
Well,
was
here,
elected
get to the point is, have you had someone, do you have an expert witness that determined what the damage to the value of the land is? I don't imagine me letting this go to a trial unless we have some expert testimony that's necessary, rather than someone to speculate, well, it did $50,000 worth of damage to my property.
We just didn't want to lay out the expense of an appraiser until we knew we were going to have a trial. We felt
Well,
like.
it appears to me that you're going to have a trial if they've not offered you anything that will settle it, and then we'll let the Court of Appeals decide whether they waive that or not, you know, as far as the defense, you know. So you need to go back, your clients are hearing this, you need to get someone at least to give a thumbnail estimate at what kind of damage, if any, they've received. It doesn't I mean, if they have a guarantee of a right of way and guarantee of utilities and that sort of stuff, those are the sorts of things as access that usually damage the value of the property.
My client was brought in this originally because they purchased the property from Kruger in the interim period from when there was no pending lawsuits, and they were trying to recapture the land from my clients, but there was nothing of record in the public. So I think Mr. Bowden, we've agreed to Our property lines are as the plat shows.
Okay,
And we lost acreage as a result of that, and that's part of our claim too. But again,
Uncle Acres is a result of what? The plat?
the plat that was originally done, we weren't supposed to have to file a lawsuit and spend years.
Did you agree with the plat?
My
Your
clients
client
agreed with the plat, yes.
I don't understand.
That would be something for the appraiser to testify to the court about anyway.
Well, I mean, if they agreed to the plat to settle an agreement, and then it didn't get settled, you know, I don't understand why these folks couldn't rely upon the record when they bought that property. If you did a title search and the plat was there, your client was relying on the plat, right? Yeah, I mean, what? I don't understand how you can go back and, because they didn't follow through and have all the documents done, you get that order on your clients ready, and then we'll decide, I'll let you present whatever you have on that. On the rest of it, it doesn't appear that you have much to me. I mean, the fact that a plat was done, you agreed to, and then the property was sold without that right of way being recognized. So now you want to go back to pre-plat and claim some property that belonged to these people that bought it when the record didn't indicate there wasn't any plat there. Is that
Our claim is not just regarding the plat. There were terms in this agreement that was
yeah, but
supposed to
these
settle this
people
case.
bought it without any record knowledge. Isn't that correct?
That's correct, and that's why.
We bought it without any.
Yeah,
That's why we're not seeking monetary damages against his client,
They seek solely monetary damages against the estate of Urban.
because he's the one that broke the agreement in the first place.
Well, you want the agreement enforced.
We're wanting damages for the breach.
I understand, but I don't understand if you get the full benefit of what the agreement was, how you had any damages.
My client can't make him whole with the right of way. They're saying that prior to the plat, that there was different, they didn't agree that should be the proper acreage that Mr. Kruger could sell. Is that safe to say?
There were several things in the agreement regarding transfers of the land that were
You have
supposed
a
to.
copy of the agreement?
Yes.
Who drew up the agreement?
I believe it was Elpo, yes.
Elpo filed the suit initially.
Sorry, Your Honor, there's quite a bit of paperwork in this, as you know.
Well, have you underlined the portions of it that have not been followed through?
No, Your Honor, I wasn't expecting to be tendering it today. So I did not prepare it as an exhibit. If you'd like, I can further brief this, point out what we're looking for. Whatever would assist the court in making a decision.
Have you all sat down to has the estate sat down and to determine what they claim wasn't complied with in the agreement?
We have attempted to, and it appears as though they want damages for 3 acres, which they did not receive through this deal. And so we've offered $7,500, that's $2,500 per acre. I think they further seek attorney's fees, but we're willing to negotiate.
Does the contract call for attorney's fees?
Not that
How do you get attorney's fees in Kentucky if the contract doesn't call for them?
Statute has to say it. Contract.
And have y'all mediated this thing?
we mediated this, Your Honor, when Mr. Kruger was still alive, and he offered us 20 acres that we already own, and that was the best offer we got.
Brown was not involved.
No, she was not involved. My recollection was that there was attorney's fees. It was somewhere in here, but I'm not seeing it, Your Honor. No, yeah, here it is. Should either party be required to file a lawsuit to enforce any provision herein or to recover damages for the breach of this agreement, the prevailing party shall be entitled to payment by the other party of all reasonable costs, charges, expenses, including attorney's fees, trial and appellate courts, and so forth,
So if you won $1, you could get attorney's fees.
according to this.
Well, that's what you want to accord to, isn't it? And you tried to mediate.
We did
Would you
mediate, yes.
Well, that was with Mr. Kruger, and I knew Mr. Kruger well. He was not very.
Would not a mediator, not to say ill of the dead. You want to try to get him to mediate one more time before we go to trial?
I'll speak to my clients about that. I have no problem with another
Yeah, well, we
mediation.
can't use Bobby Richardson to do it because he was involved in it. You know, you got the former Chief Justice that does mediations down in this area, Justice Lambert. I guess I don't know whether Dodie George does any mediation now. I think he might have gotten out of the mediation business. Who in Glasgow does mediations now besides,
Yeah.
Yeah, that's who I used to know.
was the Chief Justice acceptable to you at former Chief Justice Lambert? Is he acceptable? I mean, he doesn't know anybody down here, you know?
I can't argue that he doesn't qualify.
Yeah, okay. Let's just see if your clients will agree to mediation. We'll go ahead and do an agreed judgment on.
And all we're going to, my anticipate is, we bought the property per the plat. We agree that there is a public right of way that is shown on the plat. And that's all and then we're out.
And you acknowledge that there previously been utility right of way sign. It wouldn't hurt to put that in the,
And as the utility right of ways that's depicted on the plat, we bought the property subject to what was depicted on the plat.
well, I would like for them to be mentioned that they were depicted on the plat just for the comfort of his clients, you know, that there was utility and water right of ways depicted on the plat, and you acknowledge those, and that you acknowledge the right to use of that as indicated by the plat. Now, that ought to take care of their permanent access to utilities and road, and have a document they can refer to and further it when it is off conveyed sometime, you know, and it'll be mentioned in the deed. And as far as the problem here, as far as the damages are concerned, let's see if we can get a mediation. I want you to clearly define for me within, let's say, 10 days, what damages that you're seeking, what you've lost, so there'll be a clear understanding with the estate as to what you've lost by the violation of the decedent of agreement, what you're exactly saying. And that will get ready for the mediation. If you'll send me a copy of that, and then if your client's willing to go to mediation, at least the mediation won't be as expensive then, because we will have defined the issues that we're mediating. You see what I'm saying? Because I read, it's hard to follow, just tell you the truth, if you don't know who's on first and who's on second, okay?
I understand.
Okay, thank y'all very much. Yeah.
Judge.
Yes.
All the parties are still here, and I can almost make this out. On this plat, it is marked a 50-foot right away from the end of the county maintenance along an existing road way to the property of Agri Rich LLC. That's what it shows.
Well, then it won't be in trouble including that in the judgment, that y'all acknowledge that.
That the plan is accurate as to the location of the easements and the electric lines.
That's right.
Or utility.
Yeah, that'll get y'all out of it cheap enough.
Thank you.
Credit Acceptance Corporation versus Ashley Scott.
Good afternoon, Judge. William Rich on behalf of the plaintiff. It's a motion for default judgment. The defendant was served, I think, April the 14th of this year. We have no response of pleading.
Okay. Will you electronically submit the judgment?
It should already be submitted, Your Honor. It should be in the file.
Okay. Thank you very much.
Thanks, Judge. Appreciate it. Have a good day.
Yeah. Okay, does that finish the civil docket? We got a confidential matter to take up, I think, at 2:00, and it's now 2:06. So anybody that's not involved, we'll turn the cameras off here. Is anybody here to participate in the confidential matter that's on the cameras?
I believe I am, Your Honor.
Okay, okay. I've got Dr. Shannon Wilson on there, and I've got Natalie Dixon. Ms. Dixon, will you turn your microphone on?
It's on.
It is now. What's your involvement?